What's up, everybody? I'm attorney Eric Scramlin, and this is the Tactical In-Service Podcast, a podcast for law enforcement where I break down case law and training topics to help you, the law enforcement community, stay up on the law. Today, I'm going to be talking about a recent United States Supreme Court decision, Lange versus California. It was released in June of 2021. In this case, the court addresses whether or not exigent circumstances always applies when a police officer is pursuing a fleeing misdemeanor suspect. Before I jump into the case law, though, if I can ask you to take a second to hit the subscribe button down there. If you're listening to the podcast, it's available on pretty much any app that you can listen to podcasts on. So add us to your favorites. Give us a follow on this channel, on this podcast. I break down the case law and go over training topics specifically for the law enforcement community to help you stay up on the law. All right, so let's jump into Lange versus California. I want to start with going through the facts of the case, and then we'll kind of go from there. So what happened in Lange versus California? I like what the court put in the opinion. They say it's fair to say that Lange was looking for attention. Essentially, you had a California Highway Patrol officer that was in traffic and noticed Lange at a red light, had his windows down, and was blaring music and was laying on his horn, just honking his horn repeatedly. This obviously got the attention of the officer. When the light changed and traffic started moving, the officer positioned himself behind Lange and then at some point turns on his overhead lights to make a traffic stop of Lange. The opinion states that Lange was about 100 feet from his house, disregards the lights, and pulls into his driveway, gets out of his vehicle, and goes into his garage. Okay, and the officer follows into the garage. The officer immediately can tell that he's intoxicated. They do field sobriety tests, and Lange, I believe, was like twice the legal limit or something like that. So he gets prosecuted for DWI and a noise violation. It's also important to note that the state argued that they had probable cause to arrest Lange based on the misdemeanor of failing to comply with a police signal. So what's the issue in the case? Well, we have an officer who believes a suspect has committed a misdemeanor. The suspect has fled into his garage, which is at this point, based on the case law, pretty much accepted in most situations as being protected under the Fourth Amendment. So the question in front of the court was whether the pursuit, I'll read you the exact issue that's listed in the opinion. The court said the question presented here is whether the pursuit of a fleeing misdemeanor suspect always, or more legally put, categorically qualifies as an exigent circumstance. So basically what the court's saying here is anytime an officer has probable cause to believe that someone has committed a misdemeanor and that person's in a public place and then flees into their home, does that automatically create an exception to the warrant requirement where the officer can then pursue them into the home without a warrant? The court answers, no, it is not. The court refuses to grant a blanket exception to the warrant requirement just because someone's committed a misdemeanor and you have probable cause and it happens in a public place does not automatically by itself allow an officer to pursue that misdemeanor suspect into their home without a warrant. The court says there's ways of doing it, but we have to go and we have to look at exigent circumstances. So I'm going to break that down a little bit more for you guys, but before I do that, let's take a step back and let's take a look at what we know about exigent circumstances, that exception to the warrant requirement as it applies kind of leading up to Lange and where we're at today. So as you know, if you've taken any of my courses, I always talk about the golden rule that any officer should always, always, always start with. And this, whenever I'd get a call from an officer as a prosecutor, we always try to figure out, do we have time to get a warrant? Can we get a warrant? Because you always start with the analysis under the Fourth Amendment, get a warrant. So we know from the United States Supreme Court in Kentucky versus King that the Fourth Amendment requires that police get a warrant before entering a home without permission. The Supreme Court has stated again and again that an officer may make a warrantless entry when the exigencies of the situation create a compelling law enforcement need. The exigent circumstances exception to the warrant requirement enables law enforcement to handle emergency situations presenting a compelling need for official action and no time to secure a warrant. So if you look at Kentucky versus King, 563 U.S. 4, 52 of 2011 case, that's a good case to get you buffed up on essentially the current state of exigent circumstances. So the court mentions it's very important that we start with the idea that we got to get a warrant, but there may be emergency situations where we don't have time to get a warrant, and those are the situations that we look to that would qualify as an exigent circumstances. The court has identified a few different categories of exigent circumstances that would qualify as an emergency situation when there's no time to get a warrant. Essentially, there's three categories. Number one is what we call the emergency assistance doctrine. Number two is to prevent the imminent destruction of evidence. And number three is to prevent a suspect's escape. The court applies a case-by-case exigency analysis, and they have not created a bright line rule. So what that means is the court looks at each case, they look at the facts, the totality of circumstances to determine if there's an emergency need for law enforcement to not wait to get a warrant and go in the house now. And it's usually based on these three categories: emergency assistance, imminent destruction of evidence, or preventing a suspect's escape. I also want to point out a case, United States versus Santana, where the United States Supreme Court upheld a warrantless entry involving hot pursuit. So even there, however, though, with a felony, it was a felony that was suspected to be committed. It was based upon imminent destruction of evidence. So if you look at that case, the court says you did have pursuit of a fleeing felon, but the court also said it fit that category of the need to go in now to prevent the imminent destruction of evidence. So even with felonies, the court does a case-by-case analysis and requires that one of these three categories I just mentioned are met. So the issue here that was in front of the court, as I mentioned, was whether or not the fact that a suspect commits a misdemeanor all by itself categorically allows an officer to chase that person into the house under a hot pursuit theory. And of course, the court said no. The court refused to grant that blanket exception. I want to talk a little bit about the court's analysis. I think it's important to know why the court ruled the way it did. There's a couple things that caught my attention about the opinion. First of all, the court recognized, and we see this again and again in Supreme Court decisions, that there's a long-standing principle that the home, as they call it, is first among equals when it comes to Fourth Amendment protections. I mean, they go in again and again and talk about that the home is the castle. This is where a man or a woman has their privacy, their freedom, and the court is going to be very, very skeptical about ever granting more permissions to go in the house without a warrant, and we see that reflected in this case. Also, I want to point out the severity of the crime is really going to come into play when we talk about these hot pursuit cases. In Wisconsin versus Welsh, another Supreme Court decision, the court held that a minor misdemeanor offense does not justify a warrantless entry. So that was a case that happened before Lange, where we kind of already had this idea that minor misdemeanors were not going to be enough to get into the house. And then the court, of course, reiterates that in its decision here in Lange. So the severity of the crime is going to play a big part of a hot pursuit analysis. The court spends a lot of time in the decision talking about, common law, what was a felony and what was a misdemeanor. Essentially, like, felonies were things like murder, rape, these big time felonies. But now in most states, there's all kinds of misdemeanors that are very minor, like, not cutting your weeds in your yard, or I think the court mentions like the improper cutting down of a tree could be a misdemeanor. Here in New Mexico, one of my favorites, a failure to label a secondhand watch. So there's a number of misdemeanors out there that clearly are not as serious as a lot of the felonies, which means why do we need to chase someone in their house based on one of these minor misdemeanors? So the court really looks to the severity. So that needs to be part of your analysis. And then probably the most important part that I want you to take from this is the court is telling us that when you're dealing with a fleeing misdemeanor suspect, officers need to apply a totality of circumstances test and determine if exigency exists and if warrantless entry is necessary. So what do we mean by totality of circumstances? I've talked about this in some other videos in some of my courses. Totality of circumstances you need to think about as a big picture, a 30,000-foot view, looking at all the facts that you can articulate. Can you articulate an emergency that necessitates a warrantless entry into the house? So totality of circumstances is how you want to look at whether or not you're going to decide to pursue a fleeing misdemeanor suspect. All right, so a couple key takeaways that I think you should take from Lange versus California. Number one, your home is your castle. It's first among equals, as the court put it. So that means as an officer, you really need to be aware, you need to be prepared, you need to be familiar with the case law, because whenever you enter someone's house without a warrant, you're going to have to be able to articulate some very narrow reasons why you did that. So you really need to be familiar with these exigent circumstances categories that the court has given us. You need to be mentally prepared before you're put in that situation. And the best way you can do that is by being familiar with the case law. Key takeaway number two, there's no automatic rule that allows police to pursue a fleeing misdemeanor suspect into a home. And frankly, there's no rule that allows you to chase a fleeing felon into the home all by itself. We need to be able to articulate exigent circumstances in order to justify warrantless entry. And then finally, number three, I talk about this over and over again, how important it is to be able to articulate facts, not conclusions. When you write your report, when you're mentally going through this on the scene, articulation of facts is the key to success here. So remember, totality of circumstances, big picture analysis, articulating those facts to make sure it fits in one of those categories. Because if you can't articulate the facts to fit one of these categories of exigent circumstances, then you need to get a warrant. It's not going to be justified to go in the home without a warrant. So you need to be able to articulate those facts. If you do go in the house, you need to make sure that it fits one of those categories, which means you need to articulate the things that indicated that it was, categorically one of these exigent circumstances that the court recognizes. So what kind of things do you want to look for when you're articulating these facts? This is what the court's looking for. Is there some facts that indicate destruction of evidence? If you don't go in right now and chase this person, you have facts that you can articulate that will show that evidence is going to be destroyed. Risk of flight of the suspect. If you have severity of the crime is going to play into this. But if you have facts to indicate that if you don't go in now, there's a danger the suspect could escape, that's going to be something you want to articulate. And then another big one is ensuring officer safety or, the public at large. This comes into play a lot with the felonies, but it can come into play with misdemeanors as well. Is it a safety risk that you can articulate based on the facts and circumstances to allow this person to retreat in the home and wait to get a warrant? You need to be able to articulate those things. I hope this sheds some light on this case. I hope this helps you understand the exigent circumstances better. There's so much that you should really look at and understand with exigent circumstances, way more than I can cover in a 10, 15 minute video. So I encourage everybody to take a few minutes, read the opinion. I think it's a very well written opinion. It kind of brings you up to speed on the current state of the case law regarding the Fourth Amendment as it applies to a person's home and what the categories are that the court will allow law enforcement to enter under an exigent circumstances analysis. So thanks again, everybody. Make sure you hit that subscribe button down there so you can be informed whenever I come out with a new video or break down any case law. If you want more information or you are thinking about bringing me in to teach a full search and seizure course, you can go to my website at tacticalattorney.com. You can find more information there. Until next time, everybody, stay safe out there, and remember, every battle is won before it's fought. See you in the next episode.